We are recording. And what I'm going to do is just make a couple of announcements, and then we'll go to David. Welcome, everybody. Welcome to White Collar Week Tuesday Night Speaker Series. We do this once a month, and this is an open meeting, so anybody can join. You do not have to be directly justice impacted to join this meeting that we do on Tuesday nights. We also have a meeting every Monday night for people who are exclusively justice impacted. And we've been doing that for 7 years. Last Monday was our 365th meeting. That was last night. And it's a wonderful way to make connections, come out of isolation and into community, and learn more about what everyone else's experience is, and hopefully identify and get some coping mechanisms and resources that you can use through your journey. I only have one announcement to make, and that's next month for our Tuesday night call, our Tuesday night meeting on July 18th. Our speaker is going to be Sam Patton, and that's going to be an interesting one. Sam was a Russiagate defendant, so he actually went to prison for all kinds of things. I'm not going to put words in his mouth, but related to his being a political advisor to some foreign countries. He was an associate of Paul Manafort's, and controversial, complicated. He's in the news all the time. He's written a new book, and so we're going to give him some time next month, and it should be absolutely fascinating. More to come. We'll send it out in the emails. We'll put it on social media. And in a few minutes, I will put the link in chat so you can register for Sam Patton. So tonight we have, I gotta find you, David B. Smith. He's an attorney and one of the few, if only, attorneys in the country who are specializing in restitution and foreclosure collection cases. Many of us know that that the government has stepped up their enforcement, restitution, and forfeiture, and it's just become a big topic amongst the white collar community and certain our meetings on Monday night. And so we reached out and we asked if anybody knew somebody who could help us learn the nuts and bolts of that. Bob Simmels, who was a dear friend of mine, who was my first boss when I got out of law school several years ago, in David's direction. So we've spoken to David, and he's been kind enough to give us some of his time. So the format tonight is that David will speak and make his presentation for as long as he wants, figure 40, 50, 60 minutes. And then we will go to Q&A. For tonight, Q&A is going to be in the chat only, because we and while all of us, or many of us, have forfeiture stories that we might want to share, we're not going to have time to do all that. So when we get close to the end of David's presentation, we'll open up the chat box for anyone who would like to ask questions. And please put your questions in chat, and then we'll just read them off and we'll get to them. We're not going to do oral questions tonight. It's just going to be a little too complicated to do that. So David, with that, I'm going to turn the microphone over to you, and thank you so much. And the floor is yours.
Thank you, Jeff. Thank you. Some people in this audience know me, but many don't. So I just want to briefly introduce myself and explain that there are very few forfeiture or restitution specialists in this country, and many excellent top criminal defense lawyers don't really know much about either restitution or forfeiture. They're both somewhat technical, or very technical areas of the law, and it's not really easy to become very knowledgeable about either subject without doing a lot of cases in the area, or sitting down and reading a treatise. So unfortunately, I complain over and over again that a lot of otherwise very good lawyers neglect these two aspects of a white collar criminal case. And many of my clients come to me after being poorly represented in those areas, and as a result getting a forfeiture judgment or a restitution judgment, or both, that are not correct and that over penalize them. But it's usually too late to appeal, and it's very difficult for you to get collateral relief, such as a federal habeas petition under Section 2255. It's very difficult to challenge an already.
I cannot get the audio. I mean, the audio to work on this. Any ideas?
Let me see.
I'll let you get in here.
Okay.
It's being recorded.
Yeah.
Just so happens
Oh,
that tonight is a meeting.
You see your voice?
I'm sorry, I can't hear, but should I go on?
Yeah, go ahead, David. I'm sorry.
Yeah. It's very difficult. The first question I get asked often is, well, can I challenge my forfeiture and restitution order because they're wrong? I shouldn't owe this much money to the government. And I tell them it's extremely difficult to do that years after the judgment has been entered. I mean, that's another technical subject, but so I'm going to be talking about what happens when, usually years later, the Financial Litigation Unit of a U.S. Attorney's Office gets in touch with you, with a defendant who's already served their time. They're usually already done with their supervised release. They're not on probation any longer, and they often haven't heard from the U.S. Attorney's Office in many years. But all of a sudden, their case gets transferred to a new AUSA in the collections unit, or a new paralegal and these paralegals do a lot of this collection work for the FLUs, the Financial Litigation Units. And the new lawyer or paralegal, their job is to stay in touch with people who owe a lot of money, or sometimes even a little bit of money, and find out whether they're capable of paying anything towards restitution or their forfeiture money judgment. And in order to do that, they have to find out what your current financial status is. So they ask you to fill out this federal form. It's called a financial statement. It's you're swearing to the information in the form. So if you misrepresent things, you can be prosecuted for making a false statement, and you can get in trouble again. So I strongly advise people not to do that. So what can you do? Well, basically, what I do with these cases is try to help the person properly fill out the form if they have questions about, because some of the questions on the form are ambiguous, or they're not clear what exactly they're asking you to do. And then you send it into the U.S. Attorney's Office. Fairly quickly after that, they will probably come back with a proposal that you should pay so much per month towards your restitution or your forfeiture money judgment. And oftentimes that proposal is reasonable in view of your financial circumstances. Many of these folks are not, not nasty people, but some of them are, and some of them are extremely aggressive, and they may expect you to basically, live in poverty to continue to pay off your judgment. And then the question is, well, what can you do about that if they're insisting on a monthly payment that you can't afford, or they're trying to take, the last penny from your bank account? Well, you can't, basically your only alternative, if you can't negotiate a reasonable settlement with them, is to go back to the judge who sentenced you and ask the judge for him to make a decision on how much is a reasonable amount for you to pay per month, or also to prevent the government from essentially bankrupting you by taking every asset you own. For that, it's a good idea to have a lawyer, at least a lawyer who knows what they're doing. And many people just don't want to deal with the U.S. Attorney's Office themselves directly. I totally understand that. I think if you do have a lawyer who knows what they're doing, you're probably going to get a better, quote, deal from the Financial Litigation Unit than if you deal with them yourself, because most of these AUSAs are they're either busy or they're lazy, and they really don't want to be litigating this unless there's an awful lot of money involved, and they're and they're aggressive prosecutors. So what can the judge do? Well, this is an area where very few people are acquainted with these statutes that give the judge authority to limit what the government is trying to get from you in the interest of justice, or in the interest of preventing unnecessary hardship for you and your family. And there's two statutes I would point out to you. You can call me if you don't get this down. One is the Federal Debt Collection Procedures Act, and there's a provision in that act which is at 28 U.S. Code Section 3013. It's kind of it's a provision designed to allow the judge to prevent undue hardship to the debtor, and the judge can basically rely on that to put his hand up and say, the government is asking for too much, or it's unreasonable given the defendant's financial circumstances and his need to support his family. There's a second statute which also gives the judge that authority, and that's 18 U.S. Code Section 3572 D, as in David, sub D. You can cite those statutes to the judge. I found that many of the FLU lawyers are not aware of these statutes, and because nobody's ever brought it to their attention, that the judge does have the power to limit what they're asking for. And unfortunately, most judges are not aware of these statutes either. So they don't know, unless you tell them, that they have authority under these statutes. I have a case in the Southern District of New York right now where it's a classic case of overreaching by the government, and if, again, somebody who simply doesn't have the money to pay them. They're trying to take part of his Social Security, which is meager enough. It's really a ridiculous case, but I'm in front of a good judge, but the judge was not acquainted with either of these two statutes, and I don't believe the prosecutor was either. And so, the lawyer or you, if you're representing yourself, you really need to point to these statutes, because I think a lot of judges and the prosecutors think that the judge doesn't have any authority to block the government's restitution collection efforts, but he does. And the same goes for forfeiture money judgments. I guess that's about all that I wanted to say about collections. But I think the rest of there's a lot I could talk about forfeiture and restitution, but not in the time I have. You can't really scratch either subject in the amount of time I have tonight. So I think the discussion ought to focus on these collection issues and what to do when you're contacted by the FLU unit, and it comes as a shock often, because they've often neglected your case for years, and some new person comes in and all of a sudden it's got your file and they want to start afresh and find out what your financial situation is and get going again, basically. So can we now turn to questions and answers? I think in this area where it's a lot, really doesn't really deal with that much law. It deals with the practicalities of the situation. I think questions and the answers will illustrate what typically is going on and how to deal with it.
Okay, David, thank you. So let's change the format a little bit. If anyone would like to ask a question, please put your name in chat. I will call on you and you can ask David anything you want. Let's start with John Cooper.
Thank you, Jeff, and thank you very much, David. I'm dealing with future restitution issues because of my estate. I'm 75, and I'm trying to figure out how to handle a lot of these processes. I know we can't go into any detail tonight, but I would like to understand, is the restitution, you mentioned earlier that the restitution can be renewed, I guess, after 20 years, but I don't know how often that happens. Do we need to go through a restitution process after 20 years to try to get a lien removed from my house? What can you explain to me about the restitution process?
Well, 20 year, the statute says, I believe it's 18 U.S.C. 3613, says the government has 20 years to collect a restitution or fine. But the government has been able to persuade many judges to extend it for another 20 years after the first 20 years expires. I don't believe that that's consistent with the statute, although there's another statute which they can argue gives them the ability to do that. I think these two statutes are somewhat at odds with each other. But it just, what's amazing is there doesn't seem to be a single published decision from any court in the country dealing with this 20-year extension issue, which tells me that almost nobody is fighting the government on it when it happens, when they're seeking another 20-year extension. So the judges are just kind of rubber stamping what the government is asking for without really researching it. And they're assuming the government has some basis for doing that, but that's a big assumption, which I think is wrong.
Okay, I'm sorry, just very quick follow-up. A part of my restitution is money going to the IRS. And there's a statute that says 10 years for IRS. Is that superseded by the 20 years? And otherwise, we just have to meet to discuss this stuff.
Are you sure that the restitution is going to the IRS, or you just have a typical tax debt to the IRS, an assessment?
I had a judgment that said part of it, the restitution goes to the a defendant, I'm sorry,
The IRS.
a party, and part of it goes to the IRS that's from unpaid taxes. So the judge put the both together into the judgment. So I'm not sure.
And the judgment says the IRS only has 10 years?
No, it says the IRS gets some of the money and the other person gets some of the money.
But
So I don't know.
what makes you think that the IRS only has 10 years to collect it?
Well, there's a general set of statutes that say they only have 10 years, but that's maybe superseded by the criminal statute.
Yeah, I would think so. And maybe the statute you're referring to, I'm not familiar with, but I suspect that's only for perhaps tax debts, civil tax obligations. I don't know. But it's actually under the federal restitution statute. One would think they have 20 years, just like any other government agency.
And the last thing, I've been paying into it. The government says they don't have a.
John, why don't we move on to some other questions, and if we have some
Sure,
time, we'll
yeah.
get back to you. Is that okay?
Sure, thank you, Joe.
All right, thank you so much. All right, and who's next is let me see, Maria, and then I'll put the names in chat. Maria, then Hope. Thank you.
Thank you, Jeff. Thank you, David. I have two questions, all related. You said that we go to the judge to ask for the restitution, so to modify or put some order on it. Is the U.S. attorney the same U.S. attorney that was in your case? That's my question number one. And are we allowed to ask the disbursement of that money that we pay? Is there any way we can find out if they've been paying that to the victims? And those are my two questions.
Your question is, you want to find out whether the government's actually going to pay the victim your money,
If paying the victim,
or
paying the victim with the money.
or are
That
you
we're paying.
or are you asking, can you pay the victim directly rather than pay the LU unit?
Yes. Can I negotiate with the victim directly, or can I ask the government to show me that they have been paying the victim with the money I've been paying the government?
Well, you can try to some people, settle these claims with the victim. The restitution statute allows you to do that, and that can often save you money because the victim may be willing to settle for a lot less than the restitution judgment you got. But it's not binding on the government, meaning, if the government may be satisfied, and that's great, and then you're done. But if they think the victim should be getting a lot more money, or it's often the case that there's a lot more than one victim, and you settle with one victim, but you've got 10 other victims that you didn't settle with, so they can keep collecting. They don't have to accept they don't have to limit themselves to the settlement you've worked out on your own with the victim, even after you honored that settlement and paid the victim. it doesn't prevent them from continuing to ask for the full restitution that the court ordered. And it's, footnote to that is, it's very difficult to settle these cases, the restitution cases with the government after, long after the judgment is entered, because usually there's more than one victim. And if there's a lot of victims, the prosecutor doesn't want to have to go contact every victim and get their consent to the settlement that you're proposing. It's too much work for them. They just won't do it. So I found it's very difficult to actually get a settlement. But that's different than getting working something out for a payment schedule or something like that. That I found is not difficult to do. It's just, but a payment schedule adjustment is not the same thing as getting rid of the restitution judgment by a settlement. It's getting rid of the judgment altogether. That's a difficult job. And they're not likely to agree to that because it's too much bother for them. So, okay, we want to do the next question. Somebody else?
Hi, yes, thank you, David. This is Hope Edmond. I had a question. You mentioned the FLU, Financial Litigation Unit, which often requires you to fill out that packet even after you've finished your probation period. What if you decide not to fill out that packet? Because just like you stated, it's very ambiguous and you don't want to get yourself caught up trying to understand exactly what they want you to fill out. And then you mistakenly or inadvertently, put something down that they considered after they do their investigation or review or due diligence on that application that, oh, you didn't mean to put that, or it wasn't like the correct amount or guesstimated amount. So what if you choose to avert filling that financial packet out altogether? Is there
Well,
any underlying consequences that they can bring against you?
Yeah, I strongly recommend against refusing to fill out the form. I mean, if you have questions about, there are some ambiguous questions, and if you don't have me or some other lawyer to answer your questions, you can put those questions to the paralegal or the AUSA who you're dealing with, and they'll give you an answer. It may be an answer that the government likes, and you could dispute that, but they won't refuse to answer your questions. And if you could also, if you're not sure what they're asking for, you can write that on the form and say, I don't understand this question. Are you asking for this or are you asking for that? And that's perfectly proper, especially if you've been unable to get an answer from them. They don't lightly accuse people of lying on the form. So it's really not it's not a good excuse to say, well, if I fill out the form, I could be charged with making a false statement. The false statement has to be intentionally false. You have to know it's false. So if you just make a simple, calculation error or something, that they're not going to be able to convict you of, or they're not going to charge you with making a simple mistake if they think you're just trying to fill out the form honestly. I've never seen any of my clients get into trouble for that.
Okay, Dave, you could maybe contact email in this chat or.
Okay, I'm sorry. Our next speaker is Mary, and we will provide David's contact information. Jessica, thank you.
Hey, I have a question. I've come in contact with multiple people like myself that I don't think the victims are getting the money. Like in my case, nobody filled out a victim's form. So I've been trying to track where the money goes. I mean, does anybody know where the money goes if it's not dispersed?
David, question. What happens to disbursements of the funds? If you know. You're on mute. David, you were on mute. David, you're on mute. Can you hear us?
He's still on mute.
David, you are on mute.
Oh, I'm sorry. I don't know how that happened. I didn't touch it.
Okay.
But okay, can you hear me now?
Yes.
Yeah. The money, if the money is not being sent to the victim for a variety of reasons, like oftentimes these victims, like you said, don't fill out the forms, and often they don't stay in touch with the government, so that they change their address, and the government doesn't really make much of an effort to track them down, if any. So this is a common situation where the victim is actually not getting the money, but the money goes into this victim's fund that the government runs, and they can use that money for to compensate other victims. And remember, this is an amazing statistic. The government is only able to collect about 9% of all the outstanding restitution that has been ordered by courts across the country. 9%. So if they get some extra money from you, which they can collect, they use it to pay other victims.
Yeah, I understand that, but I've been trying to figure that out so I could do, my application for remission. And I think it says something to a remission application that I really didn't have any victims. I'm finding a lot of people didn't really have any victims. I call it ghost restitution.
Okay. Well, if there's no victims, it's a bad restitution order.
Yeah.
It shouldn't have been entered, but like I said, it's very difficult to challenge years later.
I'm still, my case is still active 10 years later. I'm still challenging it. My case is still rolling because my judge takes forever.
Well, that is forever, 10 years, and he still hasn't
Yeah,
decided.
I filed my 2255 in 2019.
I've encountered judges like that. Yes. We'll see what happens. So good luck with that. It's unfortunately.
Can you ask for Freedom of Information Act or something to get them to say a statement if the money's been dispersed or not?
Well, you can ask them. I wouldn't.
I have.
And they won't tell you.
No.
Well, you could ask the judge to require them to tell you, but I don't know if he will, because again, it won't make any difference whether it's been dispersed to the victim or not. It's not going to make a difference in your restitution obligation. So, like, maybe they'll just say, look,
That's why I was hoping I could use that with my remission application to say nobody's getting the money, nobody wanted the money. Give me restitution, give me remission.
I think you probably have a good remission case based on the fact that you say there were no real victims that in the first place. So your restitution order may well have been in a legal order, and that's a good basis for remission. It shouldn't have been entered in the first place.
Right. Thank you.
You're welcome. So can we have another question? Can people
Yeah.
hear?
Tom. Yeah, it's Mr. Smith.
Yes.
My case is a state case. And so, the matter may be different, but I I have what I think is a pretty generic question.
Sure.
And that is my victim is 10 years, more than 10 years older than I am, therefore a very old lady, and a chain smoker. So it's very possible that she's going to die before me.
Mhm.
And is my restitution order
Is it gonna-
asset of her estate, and the other way around? If I die, is my restitution order a charge against my estate?
That's a good question. I think if that old lady dies, your restitution should go to her estate. So if the 20 years hasn't expired and you can still afford to pay restitution, you're probably going to have to pay it. You can, let's say you're asking for remission, like the last lady who spoke. You could certainly point out that the victim has died. You paid restitution while she was alive, and it seems like that's a good argument for remission, but it's not a good legal argument to end your restitution obligation otherwise. Is it?
And as far as if I die, is it can they come after my estate?
That's a good question. You can argue that this is you can argue that either way, but you know what? I haven't seen a single case involving that scenario yet.
Interesting.
And so I don't know why it hasn't, doesn't seem to come up. But there's analogies to forfeit. Let's say you have a criminal forfeiture judgment. If you die, they can go after the government can go after your estate. So based on the same argument, they could try to go after your estate in a restitution case. But there is actually the case law used to be much better on these issues than it is today. But that's I can't get into that too much more.
Okay.
Which time?
Okay.
Yeah.
Yep.
And by the way, state restitution is different than federal restitution. And there are 50 states and they all have restitution as far as I know, but they have different statutes and different rules. So you can't assume it's exactly the same, although often the same kind of principles apply across the board. But there are big differences between these statutes.
Thank you.
You're welcome.
Okay, Gina, your turn.
Hi, I put my question in the comments, but I'm going for my pre-sentence investigation interview tomorrow.
Oh.
Is there anything that I can do that would help me? I've printed out and shared all my documents with my attorney, but is there anything that I should or shouldn't say during my investigation interview with probation?
Well, usually your probation interview doesn't focus much on restitution, but you will be asked questions. Presumably, you've been asked to fill out a form with your financial information. Is that correct? Probation.
Yeah, property, income,
Yeah.
investment accounts.
Right. So. Yeah, so if the probation officer is satisfied with your written statement, he or she is probably not going to ask you any questions about it because you fully, it looks like you filled out the form correctly. There's no red flags on it. On the other hand, if you raise some kind of questions in her mind by filling out the form, then it is likely she can ask you questions about your financial status and your monthly expenses and so on. Basically because she has to include that information in her pre-sentence report. And but it's very dangerous to misrepresent the facts deliberately to your probation officer, because first of all, if they find out that you've done that, they're really mad at you, and they'll, it's not good to have the probation officer mad at you because of them a lot of influence with the judge. Does that answer your question?
Yeah, we're turning everything in. I just wanted to know if there's, I guess, just not have a big conversation about it. If they have the documents, hopefully they won't ask a bunch of questions.
Yeah. If you don't have any clarifications to make on your own, then I wouldn't bring up the subject yourself. And usually your lawyer does almost all the talking during this interview. But on questions like your finances, which the lawyer probably doesn't recall the details of, if you ever went over that with him, you could be asked direct questions yourself. Again, in my experience, only if the probation officer is not totally satisfied with your written response.
Thank you.
You're welcome.
Thank you, Gina.
Good luck
Next,
with your interview.
next is Bill, then Keith, then Holly.
Well, actually, Jeff, I want to ask the question for Holly because she can't unmute.
Okay.
We'll go with her first, and then I'll jump in later. Mr. Smith,
Yes.
can you talk a little bit about, especially for those people that are off supervised release, when they're getting these questionnaires and forms from the flu, they're seems to be getting really aggressive with spousal assets, and they want to know an awful lot about everything. That really, somebody gets married after, their case, whatever it might be. Can you talk a little bit about that, and
Sure.
what are some of the things that we need to be aware of?
Yes. Well, I often hear the question or a complaint from my clients asking about why are they asking for my spouse's assets, and how much my spouse makes at their job, and so on. What is it? Because I think they realize that or they should realize that only their assets can be taken by the government. The spouse's assets are off the table. So why are they asking for details about the spouse's assets and their income if the government can't take it? Well, and the answer is, first of all, that they're required to ask about the spouse's assets, and here's why. Because if you are married to a billionaire, then your billionaire spouse is obviously going to be able to pay a large part, if not all, of your living expenses. And they need to know whether how much your spouse is going to be able to contribute to your family's living expenses, because that's a key fact for the judge and the probation officer to know, to decide two things. One, how much restitution you should be ordered to pay, and a month, and when that should kick in. In other words, sometimes it kicks in right away, even while you're at prison. Usually they don't make you pay anything until you're out of prison and you're back home working. But on the other hand, if you have a lot of money in the bank or in real estate or whatever, they'll typically go after that right away, which they're allowed to do unless the court's restitution order specifically says, government, you can only go, get these monthly payments. You can't go after any of the defendant's assets. That's a very rare order. Most judges won't say that. So, otherwise the government can or unless you get a stay pending an appeal, the government can immediately go after whatever assets you own, not your spouse's assets. Does that answer your question, Bill?
It does. It helps out very much. Thank you so much.
Okay, you're welcome. We have another question.
Thank you, Bill. Who's next? Keith, then Lee.
Thank you, Mr. Smith. So a couple of quick questions. The first one is, I have restitution, which is 10% of my income. I'm paying 10% of my income every month.
Mhm.
Why, I'm still on probation. So why would Flu contact me? I've given them, every time they ask for a financial form, I fill it out truthfully.
Yeah.
So why 3 years or 5 years from now, if I'm still owed, but I'm still paying my 10% of my income, why would they be bothering me for more?
Well, I'll tell you why. Some FLU offices require the people there, who owe them money, to fill out that financial statement every single year, once a year, because, as we all know, your financial circumstances can change pretty dramatically in 1 year. You could find a good job, you could lose your job, which goes the other way. And by the way, it's important to emphasize that not only can they increase your monthly payments depending on changes in your circumstances, but they can also decrease your monthly payments. And that is, and you can add, and even if they don't do that, you should ask them to increase your monthly payments if your financial circumstances change for the worse. One of the only good things about restitution is that part of the sentence is never fine, in the sense that they can make these adjustments as long as you're making payments, or even if you're not making a payment currently. It can go up and it can go down like a thermometer, and it all depends on what your ability is to pay without hardship. So but most offices let you go to sleep for years at a time. They don't require an annual new financial statement, but they're within their rights to do that, just to check to see has anything seriously changed in your financial status. So that does that answer your question?
Yeah, that answers that question. But the how do I get a list of people that actually made a claim?
A list of the people who have asked to remit.
Yeah, who have actually put in a claim for restitution.
Oh, I see. Well, that's a good question, and I'm not sure what the answer is. Have you already been sentenced, or is
Oh no, I'm on probation. I'm past.
Yeah, I see. So I guess the question is, well, why do you need to know all the people who are getting paid out of your restitution? Because as I explained to another person just before, even if you pay off one with, let's say somebody is fully paid off, that doesn't, but you've got others who are not fully paid off, or indeed, you just haven't satisfied the restitution amount the judge imposed. Technically, you still owe restitution, even though, let's assume you find out that everyone has gotten all the money that they're entitled to. They can still say, well, that's too bad, but that's great. But you're still obligated to pay the full amount. I don't think that happens very often. I certainly haven't seen a scenario like that where, all the victims were fully paid and the government was still asking for more restitution payments. I think that would be extremely rare.
Well, that was the reason for my question. So there was supposedly 57 victims in my case, and only 7 of them had actually made a claim of being defrauded. But I
Yes,
don't know how many and for how much did these victims put in a claim for. So my restitution is $2 million. So if those 7 people, it was $200,000. I want to know, do I have to pay more back than the 200,000 that the people put in claims for?
I understand, but you know what else can happen? They can be made whole. Victims, long after you're sentenced, a victim could collect on an insurance policy. They may be insured against whatever harm you did them, and they get paid by the insurance company. Then, if that happens, you're really supposed to owe the money to the insurance company. Because they paid out, not the victim, and the victim's not entitled to collect twice. So but often the insurance company doesn't put in a claim after they pay the victim. You can get these tangled questions, and the answers to them are not always clear. But and the other possibility is there's a lot of, if you're not the only defendant in the case, you may have co-defendants who also have restitution orders, and they're paying. So you are entitled to know whether the other defendants, how much they've paid towards restitution. Although I find that the government is reluctant to provide that information, probably just because it takes them some time to gather it up, and they don't want to be bothered. Not because they're trying to hide something, but you are entitled to, because once the full restitution order is paid off, it doesn't matter which defendant paid it off. Government only collected it one time. You can't get more than the restitution order. So if let's say you have a very wealthy co-defendant, he's paid the whole thing off, you're entitled to know that, because otherwise they're collecting restitution from you that they're not entitled to get. Do you understand that?
Yeah, I think just very quickly, let me try to clarify. If the people put in claims and the total amount of the claims was 200,000 and my restitution is 2 million, do I have to pay the extra 1.8 million for people that didn't put in claims?
Yeah, you do, unless you can get your restitution order to be vacated by your judge, and based on that. I mean, look, some judges are actually sympathetic to defendants, and they, even if they, the case law against you, they might reduce your restitution based on that.
Right. Okay, I don't want to take any more time because other people want to speak. So thank you very much.
Sure,
Really appreciate it.
You're welcome. Thank you, Keith. Lee.
Hey, David, thank you so much. This is really helpful.
You're welcome.
As I'm sure I've been in pre-sentence for a while, so I've now filled out my financial paperwork 6 months ago, and I'm not working and working right through that nest egg that I have. And my sentencing is getting pushed and pushed. I'm just curious, do you ever recommend that we say, hey, listen, you should take different financial documents from me, because guess what? That, $100K that I had saved away just paid, because I didn't have a job, because I have kids, and I, worked through that money in the last 18 months so that it took us to get to this point.
Mhm.
Because then they might come to me with a large forfeiture based on that kind of inaccurate number. Would you recommend that I kind of electively tell them?
Absolutely, you should tell them, because your financial situation has changed dramatically, and you'd be crazy not to tell them, because that could make a huge difference in what if anything they expect you to pay. There are times when people are paying nothing, or what they call a nominal monthly payment, like $20 a month,
Right.
because they can't afford more without significant burden to them and the family. They can't just say, well, you shouldn't eat meat, you should just eat mush instead, or bread and water. they can't do that, or some seem to think they can do that, but they can't. And so it's rare that they try to do that.
Okay, quick question too, just the difference. I have a large forfeiture and I have a even larger and ghost restitution. And I had a business partner that was 50-50, but yet we still have the same kind of number, which is grossly exaggerated. Do you ever find that the judge, should we argue right away in sentencing that these numbers are kind of joint and several instead of individual? And I'd want a more individual than joint and sever. Is it even worth having that conversation at sentencing?
It's worth having that conversation at sentencing, definitely. Or, sometimes they decide on restitution after sentence. The statute allows them to do that. They're often very complicated decisions. But with it's almost like a trial on what the restitution amount should be.
Right.
So you should, and there's this part of the restitution statute tells the judge he should apportion, if there's more than one defendant who's responsible for the same restitution, he should apportion it between them based on ability to pay and what your role in the offense was. In other words, how important were you compared to the other people in causing the loss that the restitution is supposed to make up for. So if you're one of the smaller players, or if you have less money than the other people, your lawyer at sentencing should be pounding away on that, saying, don't make because unfortunately, again, most judges don't know very little about restitution, or they're lazy, or they're in a hurry to get through the sentencing. Most judges will just say everyone is responsible for the full amount, okay? Just because that's the easiest and fastest. They don't have to think about it. But that's not the right thing to do. They should, and if you make an issue out of it, and the judge just ignores it and makes you pay as much as the ringleader, that's a good issue to appeal. Assuming you haven't waived all your rights, in a plea agreement, waive your appellate rights, but even then, you definitely should bring that to the judge's attention. On the other hand, if you're the ringleader and you're the rich guy, you probably shouldn't mention it.
Okay, thanks.
Thank you, Lee. Next is Brian.
Hi, Mr. Smith. Mine is not a restitution. Mine is a money judgment that was entered at sentencing. It was not included on my on the document originally, but at the sentencing, the prosecutor sneaked in a money judgment. There's no victims or anything. I was accused of, I was sentenced because of conspiracy to accepting a bribe. So I've always had a doubt, was that legal for them to do that at sentencing? They would sneak that in. Meanwhile, it was not part of my agreement with them. And can anything be done on a money judgment? Since it works a little bit different.
Well, you're talking about a forfeiture money judgment, right? And you're not talking about restitution now, correct?
That's correct.
Yeah. Okay. So, again, the problem, if you were sentenced years ago, your time for filing a 2255 habeas motion has almost certainly expired. And the other problem is, even if it hadn't expired, the vast majority of courts say you cannot use a section 2255 to correct an erroneous forfeiture, restitution, or fine, because that's the mere financial penalty. And they say, oh, the 2255 is designed to deal with custody issues, only the length of your sentence. And I think those are terrible decisions, because they basically leave you with no remedy unless you have, immediately appeal your sentence. And, most, for one reason or another, most people don't. And partly because they don't have the money to appeal, or they don't realize they have a good issue that they can appeal on the forfeiture or restitution. They only discover that years later, after they've learned some things. So it's unfortunate, but you're probably not going to be able to correct that error. But you always try. But if you're a sympathetic judge, again, maybe you probably know whether your judge is the kind of judge who might bend the rules a little.
Yeah, mine is 2 years old. That I was just 2 years ago. I was just very lucky that I only did 11 months of my sentence. And the judge actually is really good. If it's the same judge, he is a sympathetic judge actually.
Oh, and it's a state case, so the rules may be very different.
Well, it's a federal case. No, it's a federal case.
Oh, I see. Yeah, well, if you got a sympathetic judge, and you might have a shot with them.
Thank
No
you,
harm in
Brian.
trying.
Next is, we're going to do Kay, Jackie, then Jessica.
Thank you, Jeff. David, I just wanted to explore quickly the interplay of having paid basically a ton of, having been subjected to a ton of forfeiture that overlaps basically the amount of restitution, and whether you can raise that at the end of the road after supervised release, when the FLU comes after you to say, you forfeited property, you sold it. Could that be applied towards the restitution balance?
Yeah, that's a good question, Kay. The Justice Department, that is the main Justice Department in Washington, the money laundering and asset recovery section chief, has authority from the Attorney General to apply a forfeiture payment towards restitution, and to give you essentially credit for the restitution by paying the forfeiture. You understand? So in other words, so you won't pay twice. They have that authority, but usually that can be part of a plea agreement that you enter into, where it's complicated, but you can, if you have a good lawyer who knows what he's doing, you can get that done as part of a plea agreement. If you qualify, meaning you're really not capable of paying both of them in full. If you're very rich, they're very likely to make you pay both. But most people can't even pay one, much less both of them. And so, but the problem is you've already been sentenced, right? And
I've been sentenced for time, and now I'm finished, waiting to finish supervised release.
yeah, so I'm not familiar with any case where somebody in your shoes who's already been sentenced, who's got both a forfeiture and a restitution judgment, has actually applied to the main justice guy and asked them to do this. It's called restoration. That's what the Justice Department calls this process, restoration. You can look it up in the U.S. Attorney's Manual. You can read all about it. But I'm not familiar with any case where it happens after you're already serving your sentence. But I mean, maybe they would consider it, especially if it's obvious you can't pay both of them. And also, if you're sympathetic, it's sympathetic facts in your case or in your personal circumstances. It's conceivable that they would do that sort of retroactively but again, I'm not aware of any such case. So my guess is it doesn't, if it happens, it's rare.
Thank you.
You're welcome.
Thank you, Kay. Jackie.
Hi, David. It's Jackie. Thank you for this. It's so helpful.
Sure. Thank you.
I know that, we spoke a couple weeks ago, but I have a question about interest. So on my judgment, I was not ordered any interest to be paid with my restitution. However, in the letter that I received that we talked about, they're charging me $5.49 a day interest.
Really? Well,
How is there a cap on interest that they're allowed to charge per annum?
well, first of all, if the judge didn't order interest on the restitution, they can't impose it themselves. But there's another provision which says if you are late in your restitution payments, they can charge you interest, and indeed they can charge you a late penalty as well. Those are very harsh provisions. So I don't know did they claim you were late on your payments?
No, I won last Friday. I actually won. They dropped it because they said I was in compliance. I've never missed a payment and I'm not in default. But in that demand letter that they send to everybody, it said, usually when they subpoenaed me, it said that I was being charged. I think it was like 0.11% annum or something like that. And it was in the recent prior to having it dropped, they said that I was being charged $5.39 a day in interest. So I went back and looked at my judgment carefully, and there was no interest imposed on that. So I didn't know if I should argue that, seeing I already won the other thing, should I let it go?
Well,
I didn't know if there was a cap.
Well, the first thing I do is ask them, what is the basis for that charge? In other words, why am I getting charged interest? I haven't been late on any of my payments. So what is the, and the judge said no interest. So what is the basis for that charge? And then go from there, because I don't really know why they're charging you interest. I mean, it seems like a mistake.
Amount they can charge?
Excuse me?
I'm sorry, is there an amount, a cap? Like the federal, like a credit card could only charge you in Connecticut. I don't know, Jeff would know, up to like 28% or something. Is there a cap that they can charge?
Yeah, there is. They can't just, act like a payday lender and charge you 100% interest. No, but I don't know what interest rate they're charging you. And you can ask about that too. Like, what is it? What is the basis for charging any interest? But also, what rate are you charging me? And where does it say what the rate should be? And I'm not sure what that rate is. It may vary from one year to the next based on, the Federal Reserve's, lending rates and stuff. I don't know the answer to that one, but get the facts, what they claim are the facts, and then go from there.
Okay, thank you so much.
You're welcome. Good luck with that.
Jackie, I don't know how exactly helpful I could be on this point, but either the interest rate will be put in the J&C, or there is a judgment interest rate. It's a civil judgment, so there's a judgment interest rate that's charged. Off the top of my head, it's 9%, but that may have changed. But
yeah, because on the demand letter, they said they were charging me 11% annum.
Well, we can check that out tomorrow. Why don't you reach out to me?
All right, thanks.
Thanks.
Yeah. By the way, it's incredibly important to make, when you're being sentenced, it's incredible. Your judge tick that little box on his standard form saying no interest, but that's incredibly important. A lot of lawyers miss that. And over the years, the interest on a big restitution judgment, or even, you know, a small one, can be enormous. And it makes a huge difference in what you ultimately pay. And it's such a little thing. I wonder if, I mean, you know, here's a good question, which I don't know the answer to. Can the judge, let's assume your lawyer screwed up and he didn't. He didn't ask the judge to say no interest. Could you go back to the judge years later and say, Judge, you know, I'm paying all this interest, and just because my lawyer didn't ask you, so I'm asking you now to tick the box? Because remember, restitution, even though the judgment is not supposed to vary, your monthly payments are supposed to vary with your ability to pay. So, you know, technically that's really a change in the restitution order. So, you know, a stickler judge would probably, no, I can't change it now, it's too late. But I think, again, a sympathetic judge who likes you might well tick the box later and relieve you of, you know, he could even make it retroactive. Nunc pro tunc, it's the Latin that is for, you know, an order that is, I'm doing it now, but it's going to be retroactive to the time when I should have done it at sentencing, but that your lawyer didn't bring it to my attention. I would try to do that because it can make an enormous difference.
Thank you so much.
You're welcome.
Thank you. Who's next? I'm scrolling. Jessica.
Yeah, thank you, Jeff. And David, thank you so much. You've actually read a few of the things that were issued in my case. David, I have two questions, and I think Jeff mentioned the beginning of this Zoom meeting about Tanya, and I think she spoke at your last meeting, and she might have mentioned about we're supposed to get an evidentiary hearing regarding restitution, and most of us probably never got that hearing regarding restitution. And if we never got that hearing and later on we discovered that the restitution amount should have been less because the loss was less, are we able to request for that hearing after the fact if we discovered some evidence? That's the first question. And the second question, David, you mentioned 3 different statutes. And I'm wondering, where in a case where there's a co-defendant and the co-defendant is making payments, but that co-defendant actually owes more, and the restitution payments are being applied to that other co-defendant's other debts that I'm not related to, how do I deal with that? And is that going to fall under the statutes that you had given us?
Well, I'm not sure what the facts are here, but if your co-defendant is paying part of your restitution, if he's on the same restitution judgment that you're on, even in part, then you're entitled to know how much has my co-defendant paid, because I don't, if he's already paid it off, I don't want to be paying it a second time.
Well, what they said is that, yes, she's making payments, but she owes more than I do because she had other transactions unrelated to me.
I understand.
You know, so they're saying, well, they applied it to her other debts. And I'm like, that's not fair. She's my co-defendant. We're jointly and severably liable, but you're not applying it to this debt. You're applying it to her other debts.
I see.
How
Well,
is that fair?
that's an unusual set of facts that I haven't run into, but you know, you can try complaining about that to the judge. You know, I mean, I think you have a legitimate issue there. I don't know of any case law dealing with that.
Would that fall under the 3 statute that you talked about, with the 28 USC 3013 or the 18 USC 3572? Do you think?
Well, you can say that you can make that claim to, you know, to show the judge that he has some authority over this collection process. Those are the statutes that give him a good deal of, you know, what they call equitable authority to make this process more fair and to avoid, you know, unjust results. So
Okay.
you can cite those statutes to him.
And as far as that hearing is concerned, that we never, if many
Hearing-
probably of us never got.
Well, typically the restitution is decided at sentencing. You did get a sentencing hearing, and there may have been very little said, or almost nothing said about the restitution. If in particular, if it was agreed to by your lawyer. In other words, if your lawyer didn't say this is wrong, I want a hearing on restitution, I want to present some evidence. Almost nothing may have been said about restitution at your sentencing. And so you're not really entitled to a hearing unless you ask for one. If your lawyer didn't ask for one, it's going to, it's too late, basically, years later to say, I want a hearing on it now.
That doesn't fall under ineffective assistance of counsel either?
Well, it is ineffective assistance of counsel, but again, that you can use ineffective assistance for a 2255 motion, but there's a 1-year time limit from the time of your last, your time to appeal expires, or your time to, your 90 days to file a cert petition. It expires after that period of time, and it's very difficult to file a 2255 after that. And the other problem, which I mentioned before, is the vast majority of courts say you can't even use a timely 2255 to attack a restitution or forfeiture judgment. There are some courts that do allow you to do that. There's also an ancient writ called a quorum nobis writ that you can, some courts will allow you to use that as a substitute for the 2255. So it is possible to attack your forfeiture or forfeiture judgment with one of with these collateral tax statutes, but most courts will not give you any relief. They won't even address the merits of the case. They'll say it's not applicable. They don't want to bother. I think a lot of it is just laziness.
Thank you
Charlie.
so much.
Thank you, Jessica. Charlie.
Thank you.
Thank you, David, for this information. I'm particularly interested in the subject, so my question is generic, not specific. Does the FLU have an obligation to convert the financial portions of the criminal judgment to a civil judgment?
No.
If it doesn't, how does that impact your obligations versus if it does? I raise it because, for example, traditional court searches that are done in part of credit searches do not cover criminal dockets. They only cover civil and bankruptcy. And the question I raise because of priority of claims to be paid to creditors.
Well, what exactly is your question?
Well, does the FLU have to convert the judgment to a civil judgment? Because you don't search criminal dockets if you're doing a credit search.
I see. I understand. Okay. No, they are not required to convert it. And as a matter of fact, if the FLU brings some kind of enforcement action against you to collect on your collect your restitution judgment, then those are actually civil actions. But very frequently, they're not required to file a separate civil action. They do it under the criminal docket number with the same judge. And many courts allow them to do that. They don't require a separately filed civil action, even though that's exactly what they're doing, filing a separate civil action for, attachment or, any of these collection remedies. So I guess that answers your question.
Thank you, Charlie. We have a couple more minutes. Does anyone else have a question? Bill, do you have still a question hanging out there or no?
Yeah, oh, yes, I do. Mr. Smith, thank you again. It's been really, really fascinating.
Thank you, Jeff.
So many of us have, as Brian alluded to earlier, money judgments or forfeitures. So I am one of those people.
Mhm.
Do forfeitures have similar sunset provisions? You know, I know from restitution it's 20 years, and then they can try to renew it as a civil, you know, or 20 years after you're off supervised release as a civil lien. And you know, with respect to forfeitures, you know, I had property confiscated as part of the original forfeiture. And, you know, I'm just wondering, am I going to get a knock on the door at some point later saying, oh, it's, you know, it's the flu, we're looking at forfeitures in the future. And, you know, we want to take that house you bought. Not that I can afford to buy a house, but I think you understand what I'm saying.
I totally understand. This issue doesn't seem to come up very much because, you know, usually the government collects your forfeiture judgment in less than 20 years. But the fact is, it's not governed by that same statute, which applies to fines and restitution. So there isn't a 20-year limit. But if they were going after you after 20 years, I would certainly try to argue to your judge that that statute should be applied to forfeiture judgments. I mean, you know, the same policy reasons apply to collection of a forfeiture judgment as to a restitution or fine. They're all criminal penalties. So, you know, it might be worth a try. But technically it doesn't apply.
Right. So theoretically, I'm towards the end of my supervised release, a couple of more months to go. And while I have that, I can expect potentially in this next, you know, once I'm off supervised release, that will still be inquiries in addition to the restitution, which I'm paying, on the forfeitures as well.
Yes, yeah, you should expect that.
Okay. Well, no, and look, I have to tell you, it is one of those areas where not a lot of people know about. So that's why I'm really glad that you were able to be here tonight, sir.
Well, it's a pleasure, and I'm glad I was able to answer so many questions that we had time for. You know, that's good, because I think in an area like this, which has a lot of practical aspects, you know, it's these individual stories of people and their questions that really stick in people's mind, and so it's a good way of teaching the subject, I think.
Yeah, and I'm very grateful for you being here. So thank you.
I'll be happy to do it again if you like, whenever it's a good time.
So so David, it's 8:30. We're gonna have to end. There are even more questions coming into chat, and they're awfully good ones. I'm gonna encourage you all to reach out to David. I'm gonna put his David, why don't you give everyone your contact information, and I'll try to find it real fast and put it into the chat.
Sure. Well, all you really have to do is, you know, Google David B as in Benjamin Smith, or, you know, Alexandria attorney, and my website is going to pop up. So that's, you know, for those of you who, you know, I have a very long email address, but I'm going to give it to you now, and you may, you know, a lot of people mess it up. It's my initials DBS at David B Smith PLC.com. Should I repeat that?
I just put your, the link to your website in the chat box. So it's David B.
Oh, good.
LLC.com.
And my email address is on my website, so is all my contact information. I'd appreciate if anybody wants to contact me, it's a good idea to email me first and tell me, you'd like to call, what's a good time, and also give me an idea of what you're calling about, what's your problem, or, what's your question. And that way I'll be better prepared to talk with you when you do call. Okay.
David, thank you. I just want to make a closing comment. Like so many things that happen in this area, criminal justice, law, all the related things. There are things that most of us would have done differently had we known what we know now. And hopefully what this means is that by spreading this information out there, the people who come behind us won't have to make the same kind of mistakes. And some of that is better lawyering, frankly. What I heard tonight is that David talked about a lot of rights that we had, but probably weren't advanced because our criminal defense lawyers just didn't know what to do or how to do it. And that's a shame. Whether it's actionable now, I can't give an opinion on that. But I can tell you that that's just the way it is. I've been at this for over 20 years, and God knows there's things I would do different had I known a lot of this. So blessings to everyone. David Smith, thank you so much for joining us tonight, and thank you for making yourself available to all of us in the future. This will be on video on our website and on YouTube. So David, I'll send you the link, and please feel free to share it, folks, with your friends and colleagues. And blessings to everyone. Have a wonderful night, and please join us next Monday night. If you'd like to join our white collar support group, we meet every Monday night. You can get more information on our website at prisonist.org or email us at info@prisonist.org, and we will get you the link to Monday night. So thank you all, and blessings.
Good night. Thank you.
Thank you.
Thank you, Mr. Smith.
You're more than welcome.
Thank you, David. It was wonderful. Wonderful and frightening.
Right. Well, hopefully a little bit less scary.
Yeah, that's right. Helpful. But
thank you so much.
You're welcome.